נשאר עוד בדיוק זמן להודיע על צאת בית המשפט להפסקה, ותהיה ישיבת אחר הצהריים, וזה לא יסתיים. מחר בבוקר ישיבה של עוד שעתיים.
החלטה מספר 69.
99. We were requested to apply our jurisdiction according to paragraph 41 of the criminal procedure, in brackets, trial upon information, and paragraph 15 of the law against Nazis and their collaborators, 1950, to admit an evidence at this stage, after the conclusion of the pleadings by the defense, on the initiative of the court, Dr. Wirber's affidavit. Dr. Wirber lives in London, and in this affidavit details in regard to the number of the victims killed at Auschwitz. As explained by the Attorney General, these numbers are known to Dr. Wirber since Dr. Wirber stayed at Auschwitz camp for 2 years. The defense objected that the court apply this law. We are not ready to resort to this exceptional jurisdiction in order to admit a written affidavit from a man who could have appeared in court and testify. Had the prosecution believed that Dr. Wirber's testimony is of such importance to justify his being called to court, especially considering that statistics from such a source may perhaps throw light on this question, but cannot give a final and conclusive answer to the question. As far as the Czechoslovak book, here was literature out of which the Attorney General requests to submit certain passages. We shall permit the passages where the children brought to Kushtovo are concerned, and this may be regarded as rebutting evidence to N19 submitted by the defense in the same matter. This we do in accordance with our jurisdiction, paragraph 15 of the law against Nazis and their collaborators, 1950. And in connection, it must be pointed out that affidavit N19 itself contains matters which may be considered as hearsay evidence. The directives for work, the reprint of 1934, will not be admitted at this stage of the trial, since this should have been submitted by the prosecution in good time if they are of importance. The affidavit by Alois Steiger, N19, to which the Attorney General wished to bring rebutting evidence, Mr. Revers. This matter was already settled by consent of both parties after Dr. Savatius agreed that the court do not rely on what was said on page 3 in regard to Becher's activities in connection with deportation to Bergen-Belsen. My colleagues, Judge Rave and Dr. Halevi, signed this decision. But
this was signed by myself and by Dr. Rave. Here now is the separate opinion of Dr. Halevi.
The report by Dr. Freudiger, and when the Attorney General wished to submit this to court, before conclusion by the prosecution in session 72, the defense objected, the learned defense objected to the last part, summing up the number of victims at Auschwitz-Birkenau in the years 42 to 44, contending that this part of the report contradicts the first part of the same report. Just now, only yesterday, the Attorney General received an affidavit under oath from Dr. Werber, one of the two who drew up this report, explaining this contradiction in quotes and to explain how the figures were arrived at and in connection with the number of those victims. I too believe that the learned Attorney General would have done better had he called Dr. Werber to testify here before the court, and would not have saved expenses to the state, and this as a result from session 72. But I believe that the court should have resorted and used the power of jurisdiction in accordance with paragraph 41 of the criminal procedure and paragraph 15 of the law against Nazis and their collaborators, 1950, to admit the said report including the affidavit by Dr. Weber, and if the learned defense so requires, to give him the opportunity to cross-examine Dr. Weber. It is to be pointed out that this evidence is connected directly with the responsibility to be borne by the accused, but seems to me important to set down the number of victims at Auschwitz-Birkenau. With this reservation, I consent to all other parts of the decision given by my two colleagues.
President of Court, in this case, what we still have to do is the submission of those passages from the Lidice book, which refer to these children which were in Puszkowo, is it? Puszkoczko? Mr. Hausner, Puszkow in German, Puszkowo, Puszczykowo in Polish. Mr. Hausner, I shall submit the passages where the fate of these particular children is discussed. Puszczykowo. And in German, Puszczykowo. President of Court, the book will be exhibit T1434. Of course, it is being admitted only subject to our ruling and the limitations set down therein. And the translation of the passage from the book will be exhibit T1433 in brackets A. I beg to correct myself, T1434, brackets A. I repeat, therefore, the book will be T1434 and the extract will be T1434, brackets A.
אני חושבת שהייתי ואמרתי שיש קשר.
אין קשר. אחר כך.
טוב, בזה הגענו לסוף גביית ההוכחות.
We now come to the end of the evidence chapter in this case, and we come to the summing up. I understand that the Attorney General has something to say. Attorney General, my question and request is that we be given time to prepare our summing up, especially considering the length of the evidence given by the accused. We want to draw up charts and lists of the testimonies, which will also facilitate the work of the court and shorten the summing up. All this needs time, and as I said, when we went into chambers, we would be grateful to be granted to be given a longer period, but we do ask that the summing up be commenced on Thursday, the 3rd of August. President of Court, if so, may we also reveal that you will not be able to conclude your summing up until the end of the coming week. Attorney General, yes, this seems to be so. President of Court, I do not wish to press. Of course, it is desirable that all this is concluded until the end of next week, because then Dr. Savatis will need a break to prepare his summing up. Mr. Hausner, this will be very difficult, extremely difficult, and the longer time we are given to draw up the summing up in our office, the more time will be saved by the court in session. President of Court, all right, what does Dr. Savatius have to say? We already discussed the matter in chambers.
Ich müsste dann, auch weil ich mein Plädoyer ja nun schriftlich einreichen musste, mit die Dolmetscher eine Möglichkeit haben, auch aus technischen Gründen 2 oder 3 Tage haben. Ich kann es noch nicht übersehen, ich werde es so kurz halten wie möglich. Das Plädoyer selbst wird verhältnismäßig kurz sein, was ich zu halten habe.
טוב, אבל שמענו פה שבקשה לדחות עכשיו עד ליום חמישי בשבוע הבא.
President of Court, we heard here a request to postpone until next Thursday. Dr. Savatius, I understand that the summing up for the prosecution will take a number of days. If so, I need 2 or 3 days, and that too because I have to submit the summing up part in writing, so that the translators get the material. After that, my pleadings will not take long. I cannot say yet how long it will take.
Das ist, wenn man genau sieht, ist es mehr wie 7 Tage. Und man kommt nun durch das Plädoyer in das nächste Wochenende herein, sodass ich dann erst um den 9. herum plädieren könnte.
If we go into the matter, we see that this sums up to 7 days, and we reach the end of the following week, so that I can sum up somewhere around the 9th of the coming month. President of Court, we in this case do not reckon in days, but in weeks, so that we know that during that week we shall be able to conclude. 1 day more, 1 day less does not make much difference.
Wenn der Ankläger die Zeit braucht, ich habe keinen Anspruch.
If the prosecution needs this time, I have no objection. Then this will be the 3rd of August, President of Court. The court will adjourn for summing up until the 3rd of August, 8:30 in the morning.
המטרה העיקרית של השלושה במקום השניים הוא שיהיה לאחר מכן.
עכשיו, וזה יהיה לא נעים.